Good evening, everyone. I can actually see that we've got 56 participants with us tonight. Anne Davies's legal updates are always one of our most popular meetings, and it's great to see that even though we've now moved online with this legal update, we've continued in that fashion. So before we introduce Anne, I would just like to note that as panelists here, we've got Lucy Pritchard, who's interim treasurer, Bob Ellis as chair, and Tony Richard as secretary. And if we've got questions from the committee later on, obviously we're here to answer those. Before we go to our main presentation, I've just got some updates and some news from IOSH that I'd like to run through. So our up and coming events that we've currently got, we've got our annual league update tonight. We are hoping still to have Jason Anker joining us on the 2nd of June, and noting the continuous lockdown and obviously good social distancing, that may be a webinar as well. The 1st of September, we do have planned to be hosted at Edwards. However, please watch this space. Please keep an eye on the committee mailer, because this may change. And then 3rd of November is our consultancy group with a presentation from Sarah Harvey on behavioural management within businesses. As I said, 2nd of June, Jason Anker. Jason Anker, I've known this gentleman for quite some time, both in my time at Southern Water and in other companies I've worked for. He was paralysed in 1993 when he actually fell off the 2nd step of a ladder. So he wasn't at the top and he wasn't actually doing anything unsafe. He slipped off the 2nd rung from the bottom. He now presents his story and how he has overcome those challenges and why he wants other people to be safe when they're at work on sites. So just some news and updates. Bob and myself had the good pleasure to attend a webinar from IOSH from Vanessa, I've forgotten her surname, from Vanessa, the director of groups. And one of the things she was saying is what IOSH has done for its members in terms of COVID-19. So a couple of the things that are worth looking out for as members of IOSH, and this also includes non-members of IOSH. These are free webinars open to any businesses. There are weekly webinars being undertaken with the World Health Organization, and also webinars with other groups focusing on how people OSH professionals can help you to manage and navigate your way through these current challenges. One of the great things that's come out is IOSH has launched its Careers Hub early. This provides additional CPD learning, it provides advice on CV writing, and also helping you plan to progress as an OSH professional. The Future Leaders community. So if you are under the age of 25 and in your OSH career, this is a network dedicated to people in that age range. Believe it or not, Bob and myself no longer qualify for that, but as much as we want to. And there is, through the advice and practice team, access to special technical knowledge and current papers written on how businesses are approaching the COVID-19 challenges. In addition to this, there has been a student bursary launched. So undergraduates can apply for this funding to help them on their OSH career. I would like to pause just on the second point on this slide. Is I'm not sure how many people are aware, but IOSH does have a benevolent fund. And this benevolent fund is available for people at this time who are struggling with the current work climate. IOSH has taken the decision, however, that membership fees are not to be included as part of the benevolent fund. They are introducing other measures to ensure, as members, you can continue to enjoy your membership through concessionary fees and through delayed payments. The reason it's taken the decision with membership fees at this time is because ultimately those fees would still need paying, however they were processed. So therefore it feels that it's better to offer concessions or a delay rather than to actually supplement them from the benevolent fund. So just moving on to the next slide there, that page there, I will pause on this slide, and this slide will be sent out as well after the meeting. So there are links to various things that IOSH has done centrally for its members in terms of approaching the COVID-19 challenges. Highlighting back on the careers hub that we have there. So this will launch Monday the 27th of April. It will be a single sign-on integration. Members will be able to access at that link. So this is, as I said, if you're looking for a new job and you'd like to focus on career development, understanding challenges of the pandemic and what as a professional body can be done to support you. And in addition to that, to help hone your CV, look at your CPD and offer a wealth of resources to enhance your future employability. So one of the questions that has been put to me, which is worth asking, is with the challenges of COVID-19 and delays in construction work, are we addressing our duties as construction clients? I say duties, but perhaps I should rephrase that, responsibilities, because you can delegate a duty, but the responsibility would still remain with you as the stakeholder. So if you consider that in construction works, there should be a construction phase plan in place, and that should be based on the hazards picked up in reasonably available information, which should form part of your pre-construction information. And in addition to that, working practices could change on site. So if you have to consider social distancing or the way work is undertaken, all of these will have an effect on the construction phase plan. So as a client, these are the questions you should be discussing with the principal contractor, because ultimately it is your responsibility as a client to ensure that certain measures are in place, a key one of those being the construction phase plan. Now, if you're in the UK, that's covered under CDM Reg 4. However, outside of the UK, the Mobiles Work Directive is delivered in Europe in various other ways. But it's worth looking at Article 7, which is actually more onerous for you as a client. But leading on from that, IOSH is holding a webinar on the 7th of May at 12:30 in the afternoon, where we'll be looking at reawakening construction sites and the steps that the intelligent client should be taking to ensure that the people they are responsible for have got the correct measures in place. I want to just hand over to Bob here to introduce our speaker this evening, Anne Davies. Bob, if I could just hand across to you there.
Of course you can, Keith. Just before I introduce Anne, I'd like to say welcome to all of the people we have online. This is our second online meeting, and I'm pleased to see, well, absolutely delighted to see that last time I looked, we've got 74 people attending the meeting, which is absolutely great. I'd also like to thank Ben Pollard and others at IOSH who have been very, very helpful in helping Keith, Lucy, Tony and other committee members on setting this up. Certainly this is keeping us in touch and giving us ideas, certainly for what will become the new normal. Anyway, without further ado, I would like to introduce Anne Davies, who is a long-time friend of the South Downs Branch. Anne is a partner at gullandcooke, and she's been presenting our annual legal update for as long as I can remember. Remembering that I'm now old and my memory isn't as good as it used to be. Anyway, over to you, Anne.
Thank you, Bob. Well, thank you very much for inviting me here again. I'll say hello to you all with my video on, and then as I'm in deepest Wales and broadband connection isn't brilliant, I'm going to reserve my bandwidth and make sure that you can hear me sufficiently clearly. I'll come back to answer questions, hopefully on video as well, but otherwise I will just switch my video off now, and Keith will help me with the slides. So before I start, we've obviously heard the phrase that we're in unprecedented times on a number of occasions in the last few weeks. I'm not going to touch on COVID in any detail during the course of this presentation, because I remind myself that it is a legal update and lots of things have happened during the course of the year, although that doesn't quite feel the case when we have been inundated by pandemic-related issues. But I say this, I think it's a fantastic opportunity for health and safety practitioners to showcase their skills during the course of the current pandemic. Those of you who've listened to me in years gone by will know that I strongly believe that health and safety should be at the core of how businesses organise themselves. It should be at the heart of the CEO's office. And I think for once we have that real opportunity to make sure that the value of the health and safety advisor, the health and safety director, is inordinately important to ensure that businesses can function. It's not to ensure that businesses can function safely, because that is now a clear requirement of any ongoing trading. And therefore, as practitioners, you all will be helping to ensure that the economy keeps going. So you will be at the heart of the HR teams, the insurance teams, the CEO's office. And Keith and Bob have already referred to the need to provide intelligent advice. I know we can rely on people who are a part of this group to do so, because you all support and assist each other. But unfortunately, there is a huge amount of inaccurate information, and that inaccurate information at times comes from things like trade associations, and particularly in the context of the construction industry, there are huge challenges there that need careful thought. And what I would ask everybody is to differentiate when they're advising between what is a legal requirement and what an organisation may want to do from a moral perspective. And that, I think, is hugely important, because a lot of things have been branded around as being a legal requirement, and it's not. And at its simplest, the regulations and the health and safety executive have made clear that the aim of all of this is to obviously control the pandemic, but the aim is that as many people should stay being able to work as is safely possible. So with those brief introductions, I'll start. What I've done for the purposes of the presentation is slightly different to what I normally do. The slides are slightly fuller because you're all sitting in front of screens, and therefore hopefully it's easier to read than when you're looking at a screen within a large room. I've also gone back to basics because I do regard this as an opportunity for organisations to be reminded of some of the basics. And I look first at Section 7 of the Health and Safety at Work Act, which is the general duties of employees at work. Time and time again, we focus on the duties of the employer, but employees have duties as well. And a lot of my clients have been saying to me, they wish they could bottle and capture the responsible attitude that the majority of workers have been showing during the course of the last few weeks. Employees are taking their own personal safety and the safety of others very, very seriously. They are asking for PPE, and we can all think what it would be like possibly in January if we visited a location and found a large proportion of individuals either not wearing their PPE or not wearing it correctly, or with some reluctance wearing it. We have now got a sea change with individuals recognising the importance of PPE to protect their health and in turn their safety. So if you're asked to advise on what the general duties of employees are, rather than broadly say, well, they have responsibilities, I think this hopefully may assist in that an employee has a duty while at work to take reasonable care for the health and safety of himself and of others. And as regards any duty or requirement imposed on his employer, to cooperate with him so far as is reasonably necessary to enable that duty to be discharged. And the employees need to be at work, so there does need to be a contract of employment. And obviously one has to take note therefore of agency workers or those that are self-employed. The employee must be at work when the act or omission occurred, and the employee must be carrying out that work in the course of their employment. And we are seeing increased investigations of individuals, and the sorts of considerations that go into a prosecution are the ones that I've listed there. Whether the employer has taken all reasonably practicable steps to avoid an accident, and therefore in those circumstances prosecutors may consider action against individual employees. If action is going to be taken against an employee, it should be considered what the systems and procedures in place were and whether they were followed, to include things like refresher training, and also looking at the employee's own history when it comes to adhering to company policies or similar acts or omissions. Now, I'm not suggesting for one moment that employers should be wielding the heavy stick of a threatened prosecution, because that clearly is not the time to be doing things like that. But where there is persistent failure on the part of employees to follow what will be new rules, which will be new habits, which will be new behaviours, all of which can be challenging at the best of times, then it is perfectly possible that the enforcement authorities will look to employees when it comes to assessing what sort of enforcement action should be taken. And clearly you may be able to help your HR teams when HR teams are looking at disciplinary action as to how they should consider disciplinary action in the context of failure to comply with safety requirements. And if we move to the next slide, what I've done is to outline in that slide typical examples of prosecutions brought against individuals. The health warning remains that these are the worst of cases, and it has to be fairly serious non-compliance and breaches that lead to a prosecution. But they happen, and sometimes they happen without individuals recognising that they are in serious breach of various regulations. So we've got an example there of an excavator striking others, and that is just a typical example of looking at pedestrian and vehicle segregation, a constant problem in relation to certain sites. We've obviously got the Hillsborough case, which is a very, very old case, and that is reflected in the fine that was imposed because of the date of the wrongdoing. We've got a lifeguard breaching various requirements in the context of a swimming pool. We've then got this Yardie case that one would think feels a bit like a Laurel and Hardy approach to working. So a potato box being put on top of a forklift to try and undertake certain work at height. And these are things that are still happening. And then Robert Harvey, he being the sole director, was prosecuted under Section 7, not under Section 37. And we'll come to look at Section 37 in a moment. It's therefore important that when one delivers a message in relation to employees' responsibility, that it's done in a positive way, but where reference is made to the potential for prosecution, that you are actually able to give some examples, and that you are able to give some examples of the sorts of fines that are imposed or more serious sanctions, such as custodial sentences or suspended custodial sentences. And you can see there. And obviously, you will all have copies of these slides, and you can go to the links to see the source material if you're interested in understanding any of those cases any further. So then we have a look at section 37, which is the next slide. So section 37 is where a company, a body corporate, is proved to have committed an offence with the consent, connivance or neglect of a director, manager, secretary or other similar officer. And secretary there doesn't mean secretary in the context of a typist, but secretary as in an officer of the company. And the person has to be acting in that capacity, and both the individual and the organisation need to be or the organisation needs to be liable for an individual to be proceeded against. And I've talked about this before, but I thought it was worth reminding you that consent and connivance imply both knowledge and a decision made on that knowledge. Neglect is obviously slightly different, but if a senior individual within an organisation consents to something or connives, i.e. turns a blind eye, then they can be prosecuted. And again, we are seeing an increase in the number of investigations against individuals and ultimately the prosecution of individuals. Those are some old cases, but they're there to remind you of some examples again that you can provide to people if they ask you questions such as, if somebody's a temporary manager brought in for a short period of time, are they likely to fall foul of section 37? And the case of Ball says that that will not be the case. It's there to catch those responsible for putting proper procedures in place. It's not meant to strike at underlings. And then Armour and Skeen, another example where the individual concerned was responsible for preparing the documents, failed to do so, and although they had title of director, he came within the definition of a manager, secretary, or other similar officer of the body corporate. And if we go to the next slide, these are the sorts of considerations that will apply. So looking at the evidence collected against the company, looking at understanding the management structure, would a prosecution make the individuals aware of the seriousness of their duties and responsibilities? Other questions such as, did the director or senior manager have effective control over the matter? Did he have or ought to have had knowledge of the circumstances surrounding the event? Did they fail to take obvious steps to prevent the event? Did they have previous warnings or advice? Was there previous advice to the company? And is responsibility shared between more than one level of management? And some of those are quite tricky. I mean, for example, did they have knowledge of the circumstances surrounding the event? Did they fail to take obvious steps to prevent the event? And this is when it comes to hindsight, because after something has gone wrong, it's terribly easy to say, well, they should have spotted that it was going wrong. But sometimes when individuals are in the middle of complex issues, they don't necessarily step back to look at whether there are signs of things going wrong. I've acted on behalf of a number of individuals. I've also acted on behalf of companies where individuals have also been prosecuted as a part of the prosecution. It's hugely stressful, and therefore it's to be avoided on all counts. But what isn't always appreciated is how easy it is for some of those questions through from A to J to be answered in the positive. Because we do, when something has gone wrong, have the benefit of stepping back and thinking. And again, bearing in mind the situation that we're all in at the moment, and bearing in mind the need and the pressure in some cases to return businesses to being more operational than they are at the moment, certainly those that are still able to operate, then there will be a lot of pressure. But it's the ability to sit back, to stand back, to look at things in the round, and to look at making sensible and well thought through decisions, and to ask for help and advice and support if that is required, and to resist the pressure to take any shortcuts, because now is definitely not the time to be taking any shortcuts. I've been asked in the past whether prosecutions against individuals mean that a body corporate is not prosecuted, and I'm still on the previous slide here. And you'll see that I've got 4 examples of how you can have a combination of prosecutions. So you can have a company being prosecuted on their own, you can have a company being prosecuted with an individual, and if that is the case, the desire is to run them in parallel. And you could have a company being prosecuted with some being prosecuted under Section 37 and others being prosecuted under Section 7. All of that, of course, creates enormous challenge, because it means that there are separate representations, because generally it means that a company and an individual need to be represented by separate solicitors. It means a lot of coordination. It means a huge amount of challenge for the organisation themselves in deciding at a very early stage what the overall strategy is going to be. Is an individual going to be supported? Are they not going to be supported? Are they going to have their legal fees met for them? Are they not? Are they really a truly awful employee that ought not to be supported? Or is there a desire to try and work through a joint strategy? And those are things that, for those of you who've been through prosecutions of that nature, will know are extremely complex issues and require very, very, very careful management. If it's a director that's been prosecuted, then it's also possible to convict a director and to then proceed to disqualification. Now again, this is not the time to alarm people, but it's also the time to remind directors of their duties. So depending on the size of the organisation that you either work for or support, you will have some who have thorough arrangements on an annual basis to remind their directors of directors' duties and to reissue the IOD HSE guidance on directors' duties. Other smaller businesses may well not have seen that guidance. And if that's the case, now is the time to make sure that all organisations have the ability to access that information, and all directors know clearly what their obligations are. And for those of you who work in very large organisations and subcontract a lot of work, then it may well be that you can help and support some of those smaller businesses by making sure that if you have a return to work plan in place at the moment, that a part of that return to work plan is not just to ask your subcontractors or your consultants for their method statements and their risk assessments and their health and safety plans, but ask them whether each and every one of their directors has refreshed their memories of the IOD HSE guidance, or if they've never seen it before, that they ought to be reading it. And if we move then to the next slide, which has some recent case law. Again, I don't intend to dwell on this, because the reason I've put it up there is sometimes it's not terribly easy to find this information without searching through various sources. And I fully appreciate that we have a lot of information that's shared through IOSH daily updates in relation to prosecutions, but sometimes those aren't brought together. So if you're asked to support some of the things that you're saying about directors' duties and about the importance of ensuring that everybody in a senior capacity is careful in the way in which they discharge their duty, these are various examples that you can provide of individuals that have been prosecuted. And again, you may sit there and think, well, this is just really very simple things. But very simple things go wrong. And in my view, there is a huge risk at the moment that we will have a number of very simple things going wrong, because people will be very focused on the bigger picture. They'll be very, very, very focused on COVID-related issues, health-related issues, and therefore, when it comes to slips, trips and falls, when it comes to access and egress, when it comes to basic housekeeping that isn't necessarily health-related, there is a risk that some of those things will slip. And I've heard a number of my clients already say that the larger organisations are obviously working very hard to put in place COVID-related arrangements, but that there is such a huge focus on that the day-to-day issues in relation to basic safety are starting to slip. And the challenge is to keep those things running in parallel. And the other thing, which I'm sure you're all very, very aware of, is that when we look at why accidents happen, and we'll consider that very briefly towards the end of this presentation, we get stuck with that behavioural explanation. Somebody did something that went contrary to their instruction, and then we ask why. And I think we all have to be very aware at the moment that people will be distracted. People will not always be concentrating on their work. They may have somebody who is ill at home. They may know somebody who is ill, and therefore their focus is not necessarily on their work. And it's exceptionally important to try and drive that message that care and attention to the little things, day-to-day issues, remains hugely important. So we look at the first one, a lack of edge protection. Again, we see that so often. The next one is asbestos, and we see so many problems with either asbestos surveys not being done properly or asbestos surveys being ignored, and failure to notify the HSE of asbestos-related work. So again, that is a hugely important area. We're looking at halves. So the third one there, Alwyn, Griffith, Hughes, Thomas. Again, things like that cannot be overlooked at this stage. Warnings have been given, but the warnings had not been adhered to. And therefore, again, a prosecution was brought against the director, and there you can see a 12-week custodial sentence, which was suspended. And over the page and on to the next slide, we've got a variety of others. And as I say, they're not intended to alarm, but they are there to help support you if necessary, give examples of cases that are prosecuted. Because if you are challenged and asked, well, were there many prosecutions in the last year? Well, you can see there that I've got 2 pages of 2019 related prosecutions, and there are quite a bit more, because on the next page I've got a selection again of others, one 2018 and others 2019. And for those of you who work in food-related businesses, then the issue surrounding allergies has become a big, big challenge. And you can see the Royal Spice takeaway there, serving a dish that led to a schoolgirl suffering an allergic reaction and dying. Now, for those of you working with food-related businesses, one of the explanations that I often have when I represent companies who are prosecuted for allergen-related breaches is that the procedure for taking an order requires a huge amount of attention to detail. Some businesses will have automated tills, some will have different colour warnings, some will have the ability to make sure that everybody in the chain, from collecting the order to placing the order to cooking the order to putting the order back on the table, know that an individual has a particular allergy. But we also know that if one person in that chain lacks concentration, makes a mistake, then the whole chain falls apart. And and it's easy for it to fall apart, because within that chain there are quite often a lot of people. So that again is an example in relation to the food industry. And if we move to the next slide, what I've done here is looked at the trends for prosecutions and companies that have been fined 200,000 plus and up to 10th of January 2020. Again, it's not always easy to find all of these in one place. Frequently we'll see individual reports coming through on various updates. But what I've tried again here is to assist you that if you are faced with organisations that say, well, £1 million fine is not that commonplace. I've got 2 pages here of fines that are in excess of 1.5 million. And I've got links enabling you to go to the case and the breach if you want to find more. So Merlin Attractions, that's the Smiley Rider, remains the top total at 5 million. Valero came in at 5 million as well, but it's been reported as 2 separate offences, which is why they're listed twice there, but they relate to the fatalities at the refinery in Pembrokeshire. And you'll see that there are a variety of dates there, so the information spans a reasonable period of time, but I didn't want to clutter your slides with more, but there are plenty more available, and many that go well over the million. Now, of course, sentencing, as we know, relies on the turnover of the organisation as setting the starting point for a fine. And the names there that you can see on that first slide, and if you look again at the next slide, they are names of very large organisations with substantial turnovers, which explain why the fines are in the realm of the millions. And perhaps, Keith, you could go to the next slide for me. Other familiar household names that will come through there as well. Now, I've talked before about sentencing. I've got one specific sentencing section coming up in a moment, but before we move on to that, my view is that when we look at the sentencing guidelines, the effect of a fine on an organisation with a small turnover or a low turnover is frequently far more serious than the impact of, say, a 1.8 million fine on Tata Steel. The proportionate or the impact of a fine on an organisation with a reasonably low turnover can be very, very serious. And I had a number of sentencing cases towards the end of last year and into the beginning of this year, where we successfully ran arguments around what was then the most popular topic of its day, Brexit, but indicating in a very methodical way the impact that Brexit might have on some of these businesses, and therefore the ability to pay a fine could put the organisation out of business unless a judge took into account the potential for serious damage to the business caused by Brexit. Obviously, at that stage, none of us had envisaged what would happen through February into March and where we now are. But just pausing there and now where we are, if anybody is working with an organisation that has had a fine imposed upon it and was given time to pay, then the courts will be very receptive to making a variation of that time to pay order. I've already done so. I had a client whose fine was due to be paid at the beginning of June, I wrote to the court explaining what the current circumstances had meant for that business and offering an alternative proposal with payments in instalments and starting from October. And that was accepted on paper without the need to go back before the court. So if any of you are in that situation, then you should be advising your businesses to look at potentially deferring the fine and rearranging how the fine ought to be paid. The next slide picks up on a topic that has led to quite a lot of cases since the guidelines came into force, and in particular a number of cases during the course of last year. And this is all about sentencing guidelines for linked organisations. So you will recall that a sentencing exercise has to follow the guidelines, and the judge has to go through those guidelines on a step-by-step basis. The judge will start with the turnover, will look at culpability, will then look at harm, and will then look at the accounts of the organisation. There is a requirement to put before the courts accounts for a period of 3 years preceding the date of the hearing. And there is a provision that says that the resources of a linked organisation may be relevant unless it can be demonstrated to the court that I'll start again. Normally, only information relating to the organisation before the court will be relevant unless it can be demonstrated to the court that the resources of a linked organisation are available and can be properly taken into account. And generally what a linked organisation means is, say, a parent company. And many organisations these days have reasonably complex structures, and there will be parents with a number of different subsidiaries for perfectly good and proper reasons. But there are occasions when, if the subsidiary that's before the court has reasonably low turnover and has a limited ability to pay a fine because it's been running on either no profits or very low profits, then the prosecution will ask the court to take into account the resources of a linked organisation. And this can be quite devastating for a wealthy parent company. Now, I appreciate that the audience here tonight is a very varied one. Some of you will work for very large organisations and will be familiar with subsidiary structures and will have some insight into where the wealth of that organisation sits. Others will be working for very small organisations where this point might be entirely irrelevant. But as a part of the opportunity that I think we currently have to remind and educate organisations about the financial risks that they run in the event that they are prosecuted, then it is quite important, even with small structures, to remind directors that linked organisations can feature. So, for example, if you have a reasonably small construction company, you have possibly one director who is also the shareholder. It has a parent company, and then we'll have possibly a development company, possibly a build company, possibly a manufacturing company. All of those subsidiaries are essentially controlled by the parent because the via simply a sole shareholder. Now, if an incident happens within one of the subsidiaries, and if they're reasonably unprofitable on their own, you will find that the authorities will immediately look, if they prosecute and sentence, to whether the resources of a linked organisation should be taken into account, i.e. the resources of the parent. It doesn't mean that the parent is prosecuted, but it just means that the parent's resources can be taken into account. And these are the sorts of questions that will be gone through. To what extent does the parent company oversee the function of the subsidiary? And again, that will depend depending on whether you're a part of a global organisation where the parent has absolutely limited involvement in the day-to-day functions, or if it's a reasonably small structure where the parent might have a huge amount of involvement on a day-to-day basis. Is there an overlap between directors of the board at parent and subsidiary level? Well, sometimes the directors of the parent will be exactly the same as the directors of the subsidiary. Do they operate in the same industry? Sometimes they don't, sometimes they don't. Is there an overlap in the procedures? And we'll look at one case in particular where the view was that the policies of the parent company were imposed upon the subsidiary, and therefore there really was an overlap in the procedures between the parent and the subsidiary. Can the parent be said to have a superior knowledge? This happened in one of the asbestos cases, where it was concluded that the parent company had superior knowledge of the way in which asbestos impacted upon employees, such that they had access to far more relevant scientific knowledge than the subsidiary. And therefore, the failings of the subsidiary were put back to the parent company. And that was one of the Cape PLC cases. Then you look at the interdependence of the finances. And this is an area where the courts have been looking quite carefully at. Are there things like intercompany loans? Is the parent company essentially keeping the subsidiary alive? Now, these are things that you would think as a safety practitioner, you wouldn't necessarily be wanting to discuss. But in advising an organisation on the consequences of not doing things safely and of the potential consequences of a prosecution and a fine, then these areas of risk need to be understood by the finance director and by the CEO. They don't want to appreciate this when the first they hear about it is somebody like me saying to them, by the way, there is a risk here that the resources of the subsidiary could be taken into account when you look at how the court will sentence the subsidiary. And hence, therefore, it's just building up that awareness that this is a very real challenge to certain organisations. So if we look at the Tata Steel case, which is on the next slide. So Tata Steel, as we all know, is a loss-making business, and it had parent company support. What the Court of Appeal said was that this was an exceptional case, and they emphasised that throughout. And what they had noticed was that in Tata's accounts, under the section on going concern, it was clear that the parent company was supporting the subsidiary. And what it said was that there was no risk that the subsidiary would go out of business because the parent was providing it with a financial lifeline. And therefore, the judge said that he had to recognise the economic reality, and that the economic reality was that Tata's losses were being borne by its parent company, and therefore there was no downward adjustment made to Tata's fine, Tata having argued that it should be reduced because of its loss-making status. And I think some of you will have heard me talk in the past about the sentencing of Mid Staffordshire Health Authority after its prosecution for the multiple deaths that occurred. And you'll remember me saying in past presentations that the court there had said that it's not the court's job to work out how a fine will be paid. It's the court's job to impose what is a proper fine based on the guidelines. Because in the Mid Staffordshire case, Mid-Staffs were arguing that because it was an NHS trust that had been running at losses for years and years and years, that it would be entirely improper to fine it anything other than a nominal £1 fine. And the judge said that that was not the appropriate way to go about matters. And then we have the next case, which is Faltic Europe. And again, here there was an issue in relation to the corporate personalities. And what the judge said was that it was very much a fact-specific investigation. And in the accounts, these words appeared, and I quote, "The company meets its day-to-day working capital requirements by having access to loans from its parent undertaking. The company is dependent on continuing financial support being available from the bank and the continued financial support, should it be required, from its parent undertaking." And therefore, again, the judge concluded that the company showed that the subsidiary had financial support from the parent, and in these, again, exceptional circumstances, the resources of the parent company were taken into account. And a similar argument was being run here by Faltic, in that they were saying that they were a loss-making business, and therefore the fine that had been imposed was too high and ought to have been reduced. And the judge said no, that they were satisfied that the fine could be paid based on the financial support of the parent company. Now the next case, which is NPS, there we are, NPS, gave rise to a slightly different point. And here the judge at first instance looked at NPS and also looked at the parent organisation. And the parent organisation was a very wealthy business and had a very substantial turnover. And what the judge did here was to add together the turnover of the parent company as well as the turnover of the subsidiary that was before the court, and therefore total the turnover to get to the starting point of the fine. And the court said that that was wrong. The starting point was to look at the entity before the court. So again, if you look at your small construction company, and if you've got a subsidiary that's turning over 2 million and the parent is turning over 8 million because it's collecting money from its various other subsidiaries, then when it comes to calculating the fine, the starting point is not to say that the entity before the court has a turnover of 10 million, 8 plus 2. The starting point is to say that the entity before the court has a turnover of 2 million. So you go to the relevant section of the sentencing guidelines to look for the 2 million. But then when it comes to looking at whether the fine should be reduced further based on the loss-making status of the entity before the court can say, no, there is a linked organisation here. There is a parent company that can afford to pay the fine and will provide the necessary support to the entity that is being prosecuted. And the final one is a far more well-known name, which is Bupa. And again, what the prosecution tried to do here was to take into account the turnover of the parent company, and an attempt was made to increase the fine from 2.25 million to 4.5 million on the basis of the turnover of the parent company. And what the court again said was that this was not a special case, such as Tata or NPS. Bupa had more than enough ability to meet the fine that it ought to be meeting without having to look to the parent company for support. And importantly, there was nothing in Bupa's accounts that said that the parent company was supporting it as a going concern. So the parent company wasn't providing any financial support to essentially keep the subsidiary alive. Now, I appreciate that that section might have been quite technical, but I do think that it's something that organisations need to be aware of, because in my experience, when I've been working with businesses that have complex structures and that the subsidiary before the court may have either very low profits or no profits at all, often they hear from me for the first time the story around the ability to look to a linked organisation. So making businesses aware. Now, it doesn't mean that the business should look at structuring itself differently. It doesn't mean that it should look at creating lots and lots of complex structures. But what it does mean is that the organisations realise that it could follow that a parent organisation's financial wherewithal can be taken into account when finalising upon a fine. So if you have an organisation, and I suspect that none of you work for those, but if you have an organisation that decides that it's intentionally going to set up the most dangerous parts of its operations to be run by a subsidiary that makes little or no money on the basis that they think that that might be a way of avoiding hefty penalties, then that should be poo-pooed pretty quickly, as it's not likely to work, bearing in mind the guidelines that the courts are working towards. Now, I'm moving on next to a different topic. Some of you, and I've seen the names of some of the participants, so some of you will have seen this before because you will have been to my seminar in February, where ironically I ran a session on how to be prepared for a health and safety crisis. And I don't claim to have had any ability to have predicted what was going to happen within a few weeks of this. But this was the last in a series of various articles that I'd written about managing a crisis, about directors' responsibilities for crisis, and how to deal with it. So for those of you who've seen and heard this, my apologies. The reason I thought it was worth rerunning is we are now in a health and safety crisis. We are likely to find that when businesses go back to work, or those that are still working are faced with incidents, there is likely to be the need for a more thorough investigation of incidents that are reported. There is a huge amount of confusion at the moment as to what the RIDO reporting means in the context of COVID-related incidents, and I'll park that. But I think any organisation will be expected as a part of the package of working safely to be more thorough in the way in which it investigates incidents and near misses. And I make no apology for saying that I think that investigating incidents is on the whole the weak link when it comes to the management of health and safety within organisations. It's not given the time it ought to be. It's not seen on the whole as adding value. And because it frequently is done hurriedly with no real focus on lessons learned, it becomes a quasi-administrative process without recognising the true value that can be derived from it. And I think now more than ever, investigating incidents in the workplace needs to be elevated to a status where they are taken seriously, where time is set aside for them to be done properly, where there is a proper programme of looking at lessons learnt. Because personally, I think it's a part of the confidence that the workforce requires to be able to be assured that they are working safely, and also that there is a mechanism by which feedback in relation to incidents can be dealt with. And it works both ways. That feedback can be feedback in relation to an organisation recognising that there are some improvements that are required, and also feedback to workers that, again, they need to be reminded of their responsibilities that we talked about earlier on, Section 7 of the Health and Safety at Work Act. So that's just a few initial bullet points on what needs to be done, and I will work through those in the next few slides. So planning the investigation. I frequently say that an investigation is another project. You do not go into a project without some form of a plan, or most people don't go into a project without some form of a plan. And it should be mapped out in the same way as any other project. So there should be a start, a middle, an end. There should be aims, there should be objectives, there should be an understanding as to who does what, who has overall responsibility for delivery of the plan, and what the timelines are going to be. So there are obviously legal reasons for investigating, as well as the need to learn from incidents, and which ones to investigate. So having a proper triage system in place, knowing which incidents are going to have which level of investigation, because not everything will need the gold-plated or platinum level, but equally the fact that there is no injury should not determine the nature of the investigation. One could have a fairly catastrophic event with no injuries, and that certainly should be triaged as a serious issue rather than not. Now, I suspect from seeing Lucy's face that there are some interesting questions coming in. So I will pause after this section to look at some questions as well. But it's then when to investigate. So looking at whether you have a proper procedure, avoiding focusing only on harm, and considering the risks that are created. Because it's the creation of risk that is the focus of the investigation, not the outcome. And we know that that is the case when it comes to sentencing. The courts will look at the creation of risk, not necessarily or not just on the harm. So if we move on then to the next slide, we've got litigation privilege. Again, I make no apology for either reminding those that already know about this, or just asking people to think about how privilege is attached. So if litigation is contemplated, then it is possible to arrange for the investigation to be done under the umbrella of litigation privilege. That does require a decision to be made very early on. And again, I know that there are a whole host of different types of organisations and representatives attending tonight. Some of you will have your 24-hour call arrangements in place with your legal team. So if an incident happens, you will have a set list of people to call, which will include somebody who can give some legal advice. And that legal advice may well be to undertake the investigation under the umbrella of privilege. The important thing being, if an investigation is prepared under privilege, then the report does not need to be disclosed to the prosecuting authorities. And the number of clients that have said to me when they've read the allegations against them, that it looks as if it's been lifted from their own investigation report, I tell them, well, it has, because they have handed over on a plate to the prosecution the prosecution. None of this is about not being transparent. I find that sometimes I'm challenged on this and saying that it's morally incorrect to prepare an investigation under the umbrella of privilege, that it's lack of transparency, that it's a failure to cooperate with the authorities. That's not the case at all. It is a way of, again, managing an organisation's risk. And we are likely to find ourselves in a phase where there will be increased litigation against organisations, certainly personal injury litigation, where individuals will feel for a variety of reasons that either they have suffered actual ill health in the form of virus-related conditions that they seek to blame their employers for, or they may well say that they've suffered stress-related symptoms because of the way in which the working arrangements have been put in place, and that has led to a work-induced stress. So it is going to be important as a part of this getting back to work or continuing to work to make sure that the accident investigation protocol has been looked at and that it is fit for purpose. So rather than just simply looking at the risk assessments and the method statements, is the accident investigation protocol appropriate? And is the issue of litigation privilege understood? And is the value of litigation privilege understood? And again, I know that there are some participants here today who will have worked with me on some investigations and will know the value that's derived from that, because what it means is that the investigation can be very transparent. It means that the board can have a huge amount of detail in relation to the incident, knowing that it's not going to have to be disclosed to the authorities. It needs a bit of control over loss adjusters, because if there's an insurance claim and if loss adjusters come to take witness statements, then material that is created by loss adjusters is not covered by privilege. Privilege is a topic in itself. I'm not going to use up what time we have this evening to talk about that in detail, but please be aware of it. Then I can skip through quite a few of these slides because they're fairly self-explanatory, but it's about setting up the investigation team. And again, I mean that as a team, this can often not be done by one person. And that's where so many organisations go wrong, in thinking that an incident investigation can be done by one. So it depends on the nature of the incident, but sometimes you'll need a small team, sometimes you'll need a larger team. You'll need to coordinate, you'll need one person to lead, you'll need to look at whether you've got the right skill set, you'll need to look at whether you've got input from workforce and management, you'll need to look at administrative support. And what I mean there is just basics help with typing up notes. Because the number of times that I have calls from people saying, sorry, it's delayed because I've got to type it up myself. Or I had an incident over the Christmas break when an individual had spent his Sunday before Christmas typing up an investigation report because there were no resources that were made available to him. So again, it's important to make sure that there is proper administrative support that can therefore relieve the individuals who have the skills to interview and to interpret facts to do so, whilst others are providing that admin support of writing up notes or transcribing notes. The next one is handling the media. Again, I don't want to say more about this other than to remind everybody to look at what the media response is within your own individual organisations. And again, we're at a time where the media will have a heightened interest in organisations that go back to work or are continuing to work. And we've already seen that in the context of the construction industry in the last few weeks, in that there has been a lot of pressure applied on certain companies, and how do those organisations respond? And we've all seen examples where organisations manage that extremely well and manage that extremely badly. But as a part of your support to your businesses, it's asking that question, what is the arrangement in relation to media handling? And the next slide is about reporting to the authorities. Again, do you know the regulations? And I've learned in the last few months in particular not to assume that they are understood, because like so many things, there is a tendency to think that any accident that happens has to fit within a certain category without going back to the regulations and reminding ourselves of what the regulations actually say. And the regulations are not about culpability. So individuals that try and argue that because somebody hasn't been hurt or because somebody is back at work within a 7-day period, that it's not a RIDDOR reportable incident, need to just go back to the RIDDOR regulations and remind themselves of what they are, because failing to RIDDOR report is a breach in itself, and that's to be avoided if at all possible. Making sure again that there's an understanding of the roles of the police, the health and safety executive and the local authorities, know the powers of the police and the health and safety inspectors, know how to manage a visit from the enforcement bodies. And we may well find that some focus will be given to particular industries in the next few months where there will be ad hoc visits. And therefore it's knowing exactly how those visits are to be organised and plan. Then I go on to the next, which is gathering the information. I won't dwell on this at all, but it is important to look at the physical information, take immediate photographs, look at what the documents are, take photographs of the equipment involved, know who was there. Now, again, this sounds pretty obvious, but sometimes 6 months later, somebody's asked, well, was so-and-so there? And they say, well, I can't now remember. Whereas if there's a proper list done and you keep your notes, then all of that information is captured because it may become relevant at a much later stage. I've put a slide about interviewing witnesses. Again, just to remind everybody and for you to remind others that help you with investigations is that it needs to be planned and prepared. You cannot just go into taking a witness statement without thinking, what are the questions that you want to ask? What are the issues that you want to cover? And how are you going to listen to the answers and respond to those answers? Because otherwise, if you haven't planned, your focus is on concentrating on asking your question rather than listening to the answer. And therefore, the process becomes quite robotic and you may well miss information that could be helpful. So it's checking whether the witness is fit to be interviewed, it's explaining the purpose, it may be that privilege needs to be explained, it's about asking open questions, it's not about making assumptions and then drafting a statement and reviewing it with witnesses. And I say don't make assumptions because it's so easy, if you know your organisation well and you know the characters involved, to make assumptions based on past behaviour, rather than just to simply have an open mind in relation to the issue. And next then, to keep the board informed, to make sure that you're following your plan, to make sure that they understand whether you've got privilege or not. Think about how you communicate with the board and think about setting arrangements in place. So for example, in a case that I was involved with last year, we, right at the beginning, agreed that there would be 2 calls a day with the senior executive team. And nobody was really going to answer questions in between those 2 calls unless they were absolutely necessary. Because we explained to the chief executive that if there was a huge trail of emails that were created, those emails potentially would have to be handed over to the enforcement bodies. So we said we will keep you informed on a call first thing in the morning and a call towards the end of the day. These will be the people on the call, and those went into the diary straight away. And that enabled a lot of discipline around the investigation. It also allowed a lot of efficiency around the investigation because time wasn't spent in fielding emails and questions and queries on an ad hoc basis. So it gave a real focus. So then provide evidence-based information and you get to your drafting of the report. Again, have a company format, look at the format that you have, keep to the facts, don't use opinion, use diagrams and photographs where you can, keep to short sentences, look at how you analyse job factors, human factors, organisational factors, look at your recommendations, put timelines against the recommendations and put owners. Because that's again an area where it's very easy to fall behind. The hard work of doing the report is completed, the recommendations are made, but there's no timeline against those recommendations and there are no owners of those recommendations. And therefore, leadership of the implementation of the recommendations falls away. Look at whether there are any trends which enable patterns to be reported back to boards. And that is a key KPI for all boards to have in mind. So that was my snapshot at investigations. Now, I'm now looking at general duties of employers, but I'm afraid for me, only the heading has, oh, there we are, the rest of the slide has come up. I think something happened there slightly. So the reason I've looked at this is now to break my promise not to speak about COVID, because I think it's really quite important that we do go back to basics when it comes to what are the duties of employers and what does reasonably practicable mean. We've all got into the habit of either preparing risk assessments or looking at risk assessments and not completely thinking about how the mitigation arrangements are put in place and whether the risk has been reduced to the lowest reasonably practicable. Obviously, it's not eliminating the risk, but has it been reduced to its lowest reasonably practicable? So have we reached ALARP levels? And there I remind everybody about what reasonably practicable means based on that National Coal Board case of 1949, which remains good law. And it's about a computation being made in which the quantum of risk is placed on one scale and the sacrifice involved in the measures necessary for averting the risk, whether in money, time or trouble, 3 words I'm sure we're all terribly familiar with, is placed in the other. And that if we show that there is a gross disproportion between them, the risk being insignificant in relation to the sacrifice, then the defendants have discharged the onus that is on them. And I elaborate there about reducing risks to ALARP levels and emphasize that it's not one of balancing the costs and benefits of measures, but rather of adopting measures except where they are ruled out because they involve grossly disproportionate sacrifices. And the reason I pause on this now is that we are all looking at a very different risk landscape. So when we are involved in reviewing risk assessments and when we are asking everybody to look at whether the risk has been reduced to ALARP levels, we are having to take into account a huge number of issues that would not have been taken into account in January or February of this year, and looking at how that balancing act can be achieved. And obviously where we go to in relation to risk assessments is regulations under the Management of Health and Safety at Work regulations, and in particular Regulation 3, which I show up on the next slide. And this looks at when a risk assessment needs to be reviewed, and that review is when there's a reason to suspect that it's no longer valid. Well, so many of the risk assessments are no longer valid, or there's been a significant change in the matters to which it relates, and where as a result of any such review, changes to the assessment are required. And again, we're in that territory. And again, it's worth reminding ourselves, because I don't know about you, but I don't every day go looking at Regulation 3 of the Management of Health and Safety at Work regulations. I know it exists, I know what it says in broad terms, but do I always go back to the actual legislation? No. But I have done that now when I've been advising organisations on what needs to be done. And of course, it's worth reminding organisations that the risk assessment should have clear and detailed reference to the principles of prevention, which are in Schedule 1. And I've listed them there because these are the things that will need to be thought about. Avoiding risk, evaluating risks that can't be avoided, combating the risk at source, adapting the work to the individual, especially when it says workplaces, choice of work equipment, choice of working and production methods, alleviating monotonous work and work at predetermined work rates, adapting to technical progress, replacing the dangerous by the non-dangerous or the less dangerous, developing an overall prevention policy, which looks at technology, organising work, work conditions, social relationships, and the influence of factors relating to the working environment. Well, we are firmly in that subparagraph G at the moment, looking at technology, ways of working differently, ways of coordinating work differently, giving collective protective measures priority over individual protective measures, and giving appropriate instructions to employees. Because however much we have lived in the past by recognising that very few risk assessments are actually read by employees, we will have to make sure that moving forward, employees are familiar with the reviewed risk assessments, that they do understand what they say, that they have seen the risk assessments, or at least have seen the summary of the key points in the risk assessments, and that the risk assessments are capable of being read by employees. Because time and time again, we have long, lengthy, detailed risk assessments that employees are expected to be able to digest and read, and are simply impossible to read or to be briefed out comprehensively. I've got one more issue to pick up on. I don't have a slide on this, but I will talk to it before I will hand back to Keith and Lucy to assist with questions. And the last point is our topic around Brexit. Now, I've been asked whether the various European directives that have been imported into domestic law will suddenly disappear, and that is not the case. And as far as the UK is concerned, then the position at the moment is very much business as normal, and compliance with the various legislation that's derived from European legislation is required. And even if that were not the case, then we have the very broad provisions of the Health and Safety at Work Act, which is not a European directive, Section 2 and Section 3, which generally are the overarching provisions that are used for enforcement in any event. Hence, the simple answer to the broad question is that there will be very little change. Obviously, there are some specific regulations that will have certain changes, but they are unique to certain industries, chemical related regulations and the like. But in broad general terms, compliance with the various regulations that have been imported into UK law is still required, and will be required, and it's highly likely that England and Wales will continue to adopt similar provisions when the Brexit arrangements have been concluded. Although we are now in territory where we are considering whether the government, to kickstart the economy, will do something in relation to some of the regulations, and will go back to the language that was used a number of years ago about the burden of regulation and about red tape. But personally, I doubt whether that is going to happen, because I think the current climate is firmly of the view that the health and safety of everybody in the workplace is an absolute priority, and I can't see there being any desire to relax those, certainly for as long as we have some of the experiences of the last few weeks in our minds. That was my presentation, and I've hopefully allowed some opportunity for questions, and I'll hand back to Keith or Lucy. Thank you.
Okay, so the first question that's come in is, are you able to say anything about foreseeability in regard to COVID-19 preparedness, particularly in terms of PPE availability and ventilators?
Let me try and understand that question. So is it a question that says, will employers potentially be liable in the event that there isn't sufficient PPE available? If I interpret the question in that way, then there's a substantial amount of debate going on at the moment in relation to this, and the view is that, as ever, a lot of these cases will be fact specific. A lot will turn on what efforts have been made to obtain PPE, how intelligent the use of that PPE is, how the assessments have been worked out as to what PPE is actually required. And there's likely to be a broad spectrum of cases where it's clear that the employer should have provided PPE and has failed, and in those cases it may well be possible to establish civil liability for compensation. And then there'll be other cases at the other end of the spectrum where somebody may not have had perfect PPE, but the employer is able to show that all reasonable steps were taken to protect the worker based on what is obviously a challenging time for sourcing PPE. When it comes to what the Health and Safety Executive have said in relation to PPE, then their main guidance really has been on using PPE properly, how it should be fitted, particularly when it relates to things such as masks. But I suspect that we will gradually have more guidance in relation to PPE in the next few weeks as the arrangements for returning to work and some relaxation of the current lockdown arrangements are put in place. But I think in broad terms, we are going to be faced with a variety of litigation that it will be difficult to necessarily predict the outcome until we start seeing how the judiciary approach this. And I have in mind, the litigation that followed from the Twin Towers, because that was again an unprecedented event that led to a huge amount of law developing around how claims could be made. And I suspect we'll also see this area develop in the way that we've seen things like stress at work develop. I also think that there will be a strong public policy approach that the judiciary will take, but it's very difficult at the moment to anticipate the full extent of how it will play out. The best advice to all organisations is that they really do their best to document the steps that they are taking, that they are following government guidelines, that they are doing their best to follow any industry guidelines, and in turn are following Public Health England guidelines or Wales or Scotland, depending on where you are, because that's the virtuous circle that the HSE are pointing towards.
Okay, thank you. So the next question we've had in is from a principal contractor who is saying they are spending an increasing amount of time responding to claims for compensation from their construction sites, where their insurers and legal advisors seem to accept that as principal contractor, they're responsible for health and safety on their sites. And always presumed responsible for alleged injuries. The question is around sort of premiums increasing significantly as a result, and is there anything they can do to protect themselves? Is it a common problem or a unique situation potentially?
Right, I am going to switch my video off because the quality of my sound has deteriorated a little, so I'm sorry about that, but I think it'll be easier that way. So again, I think from the question, it most probably touches on the point that Keith dealt with in his opening slide on client responsibilities. So on construction sites, and particularly looking at CDM, various stakeholders have various duties. And those duty holders need to be reminded of what their obligations are based on CDM. I think there possibly has been a historical tendency of thinking that everything stops with the principal contractor, and that's why it's a really good time to go back to basics. I confess myself, I have been going back to read legislation more in the last 6 weeks than I have done for a long time, because we all think we know what it says, but it's really a matter of looking at the regulations themselves and looking at the statutory provisions and working out who has responsibility. And as Keith indicated on his slide, a client has responsibility under Regulation 4 of CDM to ensure a safe working area. Now, it's to ensure that, so the client doesn't have to discharge that themselves, and the principal contractor may do so, but nevertheless, the client has a responsibility, and in particular, a client has responsibility for supplying welfare, and that is not something that is delegated. On insurers, Lucy, remind me, what was the point you said there?
Let me just double check.
Was it on premiums going up?
I think it was on premiums going up. Yeah, and is there anything? Yeah. Is it down to the insurance company, or is it sort of the situation that they are? Yeah.
Well, again, insurance companies will have their own ways of calculating premiums, and some part of that will relate to a claims history. But this again is where there is a huge amount of opportunity for the health and safety advisors to work with the insurance team, because quite often the insurance team will negotiate with insurers and with brokers without really talking about or without really talking to the safety practitioners about all the various procedures that are in place to ensure a safe place of work and how that works in practice. So it's another opportunity for coordinating the different functions within an organisation to ensure that there is a clear picture of what that organisation is doing. And a document trail is really important. At this stage, documenting everything that is being done, documenting the considerations, and being willing to alter them, and not to alter them because the previous arrangements were wrong, but to demonstrate that they are being altered because there is now an understanding of a better way of doing things. Because it's going to be very difficult to put procedures in place that are going to be entirely foolproof until those procedures are trialled. And it's really gaining feedback from the workforce as to what's working and what's not working, and having the ability to be able to respond to that. And as I say, documenting it as well, so that there is an evidence-based trail to support what the particular person there felt was an unfair pressure and responsibility placed on the principal contractors.
Thank you.
Oh, sorry, Lucy, I realise you can't see me now. I should say I've finished answering.
That's fine. I think it sounded like you'd finished. Okay, so the next question relates to social distancing, and with so much being done on Zoom and other channels like that, is there anything special we should do when interviewing or discussing health and safety using these kind of media?
Right, I'm not entirely certain whether, so interviewing
I think it's
candidates.
If interviewing, I'm presuming this is to do with sort of interviewing potentially witnesses or those involved in incidents.
Right, okay, as part of the accident investigation. Yeah. No, I mean, I think unlike me, who has an unreliable broadband and video, I wouldn't encourage people to be doing interviews without being able to be on some form of a camera or a video. I think it's recognising, and I'm no expert in this, there would be better people able to advise than me, but recognising that it's a forum that creates a barrier between you and the person that you're speaking. And one of the things that obviously is helpful when you can sit around a table with an individual is to remove those barriers and to sit in a way that makes people feel as comfortable as possible. But thereafter, it's really to make sure that you explain the process, that you agree certain protocols in relation to mics and things like this, which we did at the start of today, that we give everybody an opportunity to speak, that we don't cut people off, that we give people time, and if there's a pause, waiting to make sure that the person that we're asking the question has been able to finish, and trying best you can to replicate what you would be doing in the event that you were sitting around the table. Obviously, the ability to handwrite a statement and pass it to them isn't necessarily there, but if your typing skills are good, you can be typing up notes, and those could be emailed straight away to the person, or if you've got some admin support, then again that person could fairly quickly type up something, send it to the person, and then that is a document that you can discuss together whilst you're still on your video link or your Zoom. And I finished the answer there.
Okay, thank you. Okay, so our next question is, would you say it's good practice in an investigation to note your reasoning as to whether you believe an incident is RID or reportable or not, and also whether you believe it's a workplace accident?
Yes, I mean it's useful to make sure that that thought process is understood, and then one will know why it either was reported or was not reported, and that's my answer.
We've got another question which has come in that says, I understand the term beyond reasonable doubt could be changed to understanding by jurors. Is it possible that this could be extended to the term reasonably practicable?
Gosh, that's a big question. Now, if I was standing in front of you, I'd know who'd asked that question. So, I doubt that there will be a change to the understanding of reasonably practicable. It's a term that survived the test of time. It seems to work. It seems to have imagery that goes with it, that people can visualize what they're trying to do. So it's that balancing act. So no, I've certainly not read anything that suggests that to be the case. But if there is anything out there that somebody knows about that I haven't seen, then do please email me afterwards, and I'd be interested in seeing what it is. And that's my answer.
Okay. I believe that's the last of the questions that's come in, unless anybody has anything they would like to raise now.
I felt like being on Who Wants to Be a Millionaire, and that's my answer, my final answer.
Is that your final answer?
Yes, it is.
I think we've. I'd just like to say thank you there, Anne. I think we've exhausted our. Oh, hold on. We have one last question's coming, Lucy.
Yeah. Is there anything coming up on the horizon? So quite
apart from the sun.
Wide open question there.
Well, I must say my horizon has been sort of limited, unfortunately, to a lot of COVID-related issues recently. I think aside from regulation and aside from working out what Brexit will look like by the end of the year and into next year, what I think is an important issue for health and safety practitioners to look at is how we can really capture this apparent new behaviour that the workforce is demonstrating on the whole. I mean, I know that there are always exceptions, but I think what we are finding and what's being reported to me from the various organisations that I work for is that there is a huge willingness on the workforce to adapt, to change, to find new ways of working that can be safe. And it's capturing that behaviour, that momentum, that the importance that everybody places on their own safety and the safety of others. And I think how that can be sustained and how that can, from a horizon scanning point of view, be something that is a legacy that will be a positive out of all of this is beyond me, but it's something that I would love to see become a permanent feature of the approach of people to safety. And that's my answer.
Okay. We've had another question which is possibly for you or maybe some of my colleagues on the committee, which is around the concern that people who may have initially had a positive test for COVID-19 and later confirmed as negative, that they may be stigmatised at work and isolated. And is there any advice on how to help people in that situation?
Would you like me to take this one, Lucy?
I think, yeah, if you could.
I think at the time, I would hope that in terms of that, if that information was made public to other members of your colleagues or workplace, then you would have to have a question with your HR department or occupational health, because your health is one of the protected items under the GDPR. So therefore, if there's any health matters that were revealed, i.e. anything you tested for, any illness you had, which this is, that is one of the protected items under GDPR. And I am actually just wondering if, I can't see Anne, but I can't see if she's nodding or shaking her head, but that is correct, isn't it, Anne?
Yes, it is. I mean, information in relation to people's health is entirely private. Obviously, we have seen the potential for some of the privacy to be eroded in the interest of public health, but the basic starting point will remain to be the case. And again, we'll have to wait to see how some of the testing information is developed and what the requirements are going to be. But it's again an element of creating that work environment that people feel safe, that they feel confident, and that they feel that the organisation is doing everything that they possibly can in circumstances where there will be mistakes. You know, there will have to be an element of being forgiving when it comes to organisations and individuals having to tread difficult paths. And it'll come down to leadership at all levels. It'll be the leadership right at the top of the organisation, it'll be the leadership within the different teams. And it'll also most probably require, you know, people to have the ability to say sorry a little more quickly than in the past, and to be a little less defensive, and to have an ability to recognise that things may not have gone as well as they ought to have, and encouraging people to be supportive for improvements, rather than reporting with a view to negativity and all of those connotations.
I've just noticed to follow up on that from the point of view of the UAE. This presentation obviously is being delivered to the South Downs members in the UK. Having worked in the Middle East, there is a different culture in terms of the information that is available, but I am aware in the Middle East as well, they do have occupational health, they do have the same kind of respect about personal information, although not covered by GDPR, but I would still refer that back to your Ministry of Labour, which you have in the UAE or in Saudi Arabia, because that is a concern over personal information. But thank you very much for that clarity on the question. But with that, I would like to say thank you to Anne, thank you to Lucy. What I do want to bring your attention to is I've sent out a link in the Zoom webinar chat to our South Downs feedback form, and I would please ask all of the attendees, the participants, to follow that link or scan the QR code. It's a leap of technology, a bit too far for myself and some of others of us, but please do give us feedback. It helps us improve these and it helps them make them better. And for our final word, I would just like to hand back to our chair, Bob. And after that, Ben, it'd be very grateful if you could, after Bob's finished, close the meeting.
Thank you, Keith. I would like to add a few thanks. First of all, we had at the peak 81 participants, which for a South Downs meeting is a record, I believe. Some are South Downs members, but there are also IOSH members that have joined from a number of other branches. Like to say, you are always welcome at South Downs events. I'd also, Anne, thank you very much. You've done us proud yet again. Such a pity that you can't be with us, but as lots of other people have said, we are in unprecedented times. But your broadband held up very well from deepest Wales. So thank you very much. And I look very much forward to seeing you when we can get round to actually having a proper branch meeting. Very, very quickly before we close, just like to add thanks to Keith and Lucy for the role that they've played in this. And yet again, Ben, thank you very much for making it all happen. And members, thank you for joining us.
Thank you very much. Good night.
Thank you. Good night.